Good afternoon, everyone. I'm Mayank Vasudeva, moderator of the webinar. We are delighted to welcome you all in the webinar being organized by CCLEA and NPO Committee of ICAI. It is my pleasure to be a moderator in Know Your Law Series 114 webinar on navigating the Digital Data Protection Act, a guide for chartered accountants, on 11 September 2 to 4 p.m. I'm delighted to let you members know that the faculty for today's webinar is CEO Uday Kulkarni sir. CEO Uday Kulkarni sir is a practicing chartered accountant with a professional experience of 27 years. He is a followed member of ICAI, and Uday sir is also a certified internal auditor and also a certified information system auditor. He is a qualified as an insolvency professional under the Insolvency and Bankruptcy Code of India. Uday sir has also completed a digital forensic course and also certified data privacy solution engineer. His focus areas are information system audit, cybersecurity, forensic accounting, and fraud investigation, IBC advisory, and audit of data privacy. Uday sir has a wide experience in the various types of information system audit, external audit, and internal audit, fraud investigations, and due diligence, etc. He also appears before National Company Law Tribunal as authorized representative. Apart from practicing, Uday sir is a national faculty for forensic accounting and fraud detection course of of the Institute of Chartered Accountants of India, and also national faculty for concurrent audit of bank certification course of ICAI. He has imparted training on various aspects of forensic accounting and investigations, money laundering, legal aspects, and cybersecurity in Sri Lanka, Nepal, CA Institute, RBI Academy, National Forensic Science University, SFIO, SBI Credit Risk Academy, and NIBM. He is also a member of expert group formed for forensic accounting and investigations standards of ICA. Over to you, sir.
Yes, thank you, Mayank, for your kind introduction. And a very
Welcome.
good afternoon for all the participants. I know this is a very busy time for you because there are two reasons. First, the 15th September is hanging all over our mind to complete the tax related returns. And the second thing is that, of course, the tax audit this month is very busy for all of us because of the tax audit, tax returns to be filed. And in between that, we are going to discuss something which is essential, important for our practicing point of view. There are quite a lot of opportunities which is coming out of the provisions of this act. At the same time, there are a couple of challenges which the chartered accountants may face. Rather, I may say that we have started witnessing some of the impact of this act, DPDP Act, because when we now go for the audit of the banks, so whether it be the concurrent audit or whether it be the statutory audit of the banks, now banks are a bit hesitating to take their data into our environment. They are not allowing to share the data with even with the email sometimes, and what they are requesting us to conduct all the analysis of the transactions, all the verification of the transactions using their systems. So most of the data, whether it would be the loan related, borrowing related data or the deposit related data, you must be witnessing these practices. Banks have already adopted. So that is one of the greatest impact which really you are witnessing and which is quite likely affecting our practicing areas also. So from that point of view, the understanding of this act is becomes very essential for all the chartered accountants because, as I said, both the things are there. There are quite of opportunities which are available under this act. At the same time, there are challenges for us to be implemented in our practicing area. So basically, this act it is for the protection of the digital personal data. If you see the title of the act itself, it is intended to protect the digital personal data of the Indians, right? And that is the purpose which is also mentioned in this act. So it is all about the protection of the digital personal data. The second thing is that when they wanted to protect the data, the law is ensuring that all the persons who is collecting the data that needs to be used for the lawful purposes, for the legal purposes, and not for the illegal purposes. And now, with the artificial intelligence and whatever the misuse of that artificial intelligence which we are witnessing, it is very difficult to control some things. And that's where the provisions of this act will be very important to be noticed, as far as because recently you must have seen that even the photographs which are getting shared on the social medias of any individual, that can be morphed, that can be modified, that can be converted into the videos, and that is used for any illegal purposes. So to control all these things, there is a necessity to control this digital information or the digital data, and that should be only used for the lawful purposes. So that is one of the important provisions which is coming out of this act. And the next thing is that whether it is restricting to only the territory of India, geographical territory of the India, it's not like that. Even if we are sharing the data across the border, if some of our data, personal data of any Indian citizen, it is getting shared cross border, then in that country also they will have to follow the same rules which are there for the compliances purposes within India. And just wanted to share with you that this is ours is not the first act in these directions, because you must be witness that lot of information, lot of our personal data is getting exchanged across the digital platform, and we never know what we are sharing, for what purposes we are sharing, how it is going to be used, where it is going to be stored. So all these questions are rightfully there, which were discussed for a couple of years. And the GDPR is the first European Union's law which has taken the initiatives to protect the digital personal data. And they wanted to create the ecosystem. So you can see that almost all the countries now they have understand the importance of this personal data which is getting shared on the digital platforms. And if you know, and we all are used to that without understanding the consequences to sharing a lot of data on various website, various digital platforms, various social medias, right? Without understanding its consequences. Even many times I give the example that when we go for the various places, we don't ask why they are asking our name, why they are asking our date of birth, why they are asking our addresses, mobile numbers, etc., etc. And we share that without any asking a single question. We do not even bother about where and how they are going to store that, what is the intention, how they are going to use this data. Okay, and after the usage of the data, what will happen to my data? So what is happening to my complete data life cycle, which I'm going to share with that. Of course, in India, we are not used to have that kind of an privacy in our personal data, because you might be witness that even while traveling, if there are two Indians, they can share a lot of personal data within themselves, right? So पूरे 3 घंटे के सफर में पूरे खानदान का पता चल जाता है, right? And whatever be the disputes within the family, whatever be the good things within the family, all those get disclosed within the 3 hour journey. And that we don't bother about that, to whom we are telling again what he is going to use for that. Okay. But that is okay. That is a personal level things. But if the same thing has been started, and that is already started on the digital platforms, you might have been shared a lot of your personal photos, right? Your images in various forms at various occasions. And you don't know what is happening to them after sharing with those digital platforms, how they are going to use that, etc., etc. When we are using the various websites, right. Now you must be witnessing that they are forcefully requiring you to do certain things with their cookies. Either you deny the cookies, modify the cookies, or accept all the cookies, and so on and so forth. So the reason being is that they wanted to make a compliance with these provisions. But again, many of the times we are not aware what the cookies means, and when we are accepting the cookies, what is it going to have the impact of it on my personal information? because you know that whatever you are getting searched on any of the networking, any of the internet platform, digital platform, let us say that you are searching for a particular flight from Pune to Delhi. Okay, so today if I'm searching a flight from Pune to Delhi, so next time when you'll open that browser, it will flash you the advertisement of the various timelines of the various companies' flights on that route, right? So how this is happening? So somebody is keeping a track, somebody is keeping a watch on all my activities on the digital platform, and every activity of ours on the digital platform is getting analyzed, is getting tracked. And how this is happening? Because we have given consent in a manner of accepting all the cookies. We never bother to read about what are the contents of those cookies, right? And what conditions, what terms and conditions they are quoting in that cookies, and what will be happening if we deny those acceptance of the cookies. So these are the questions which are now having a larger impact as far as using of the personal data. Another thing which all of you are experiencing is that even you are not share the data with any of the company, any of the bank, any of the NBFC, or any of the credit card providing company, etc., etc. But still, you start getting the advertisement or the advertisement related calls related to your credit card facilities or towards your some advertisement kind of in calls, right? So then we wonder that हमने तो ये data किसी के साथ share नहीं किया था. I have not shared my mobile number with any of them. But how they get my contact, how they are reaching to me, and now they are calling you. They are sending you the SMSs. They are sending you the WhatsApp messages, WhatsApp calls. And in this busy time, if you get this call, it gets very irritative on our front. But we don't bother about that. We don't think that how these things are happening. And that is the basic thing which is coming out of the purposes which I have quoted here. So protect our personal data, the stoppage of such sharing of the data, and declaring if somebody unwantedly, unauthorizedly sharing your data to the third party without your consent, then that becomes a crime under this Data Protection Act. So all these provisions are there, which are applicable to us as a common Indian citizen, right? But in addition to that, when we are practicing as a chartered accountant, the same things are applicable, and we also need to make a compliances of certain provisions of this act, right? And that's why the today's webinar is arranged to discuss the provisions and understand the impacts and all these things, right? So let us start discussing some of the important provision. As we know that when we start understanding the impact of this act, the basic understanding of the basic provisions of this act is necessary. So first thing, as I said, the data, the act is related to for the protection of the digital personal data. Right. So what is data? That is also been defined. I'm not going into the discussion of what is data, but what is digital personal data? That needs to be understood here. So digital personal data, which is getting stored and shared in the digital form. Now, and personal data means, of course, the personal data of an individual, the human being, any individual. And the data means that individual can be identifiable by using such a data. So most probably all of us, we get identification of ours from the name which is given to us by our parents, number one. Then our family name, their or surname. That is the identification marks of ours as a personal data, right? The second thing by which someone can identify us by our date of birth, by our mobile numbers. You may be wondering that some of the some of the persons are getting remembered because only of their some mobile numbers. Our address is also our pointers to identify us, right? Our email addresses, of course, these are the personal data. Our PAN numbers, our Aadhaar numbers, our voter card ID, all these could be the pointers by which any individual can be identified, and that is treated as a personal data. Now, what is digital personal data and what is the meaning of the personal data? So only those data, whether it can be stored or processed or exchanged on the digital mode, that could be treated as a digital personal data. The answer is no. Even the form, let us say you go to the bank and the banks want you to open a customer ID. And for that purpose, they provide you the physical form, okay, the paper-based form, in which you write your all these details with your personal identification data, your name, your address, and all the stuff. So that form also, even though that is a physical paper form, that form also becomes a personal digital data, because whatever the information which is getting shared on that printed paper which you have filled, that information is in the next step is going to be entered into some digital platform or in the CBS. So that data becomes the digital personal data. So even the paper form of collection of the data, that also gets covered as a digital personal data. And the protection of that form, of course, is the requirement under this Data Protection Act. And similar requirements are there for the protection of the digital data, which is getting shared by various types of the means. Right. So this is the concept of personal data, digital personal data in the larger concept. The next, there are certain, stakeholders, which is interestingly be defined under this Data Protection Act. So there are data principal, that is a data fiduciary, and there is a data processor, right? These are the three, you can say, the basic stakeholders considering the life cycle of this data protection. We need to understand. So data principal, data fiduciary, and the data processor. So of course, who is the data principal? So you and me, we are the data principal, because it is our data which is getting shared. Right. So the individual to whom that personal data relates, that is called as a data principal. So when I'm visiting the hospital as a patient, the patient is the data principal. When I'm visiting the bank as a customer is the data principal. When the client is approaching to the chartered accountant, the client is the data principal, right? So all those customers, individual, this is, I'm talking about individual. It is not about the legal entities. It is only about the human being. It is only about the individuals, right? So all those individuals to whom their personal data is related to, those are called as a data principal. So what is there any age limit to identify any data principal? The answer is no. Even the born baby, even if the child, right, whatever be the age of that child, in the minor cases, all the childs are also treated as a data principal, right? So all the minor, major childs, all they are treated as a data principal. Only differentiating point is that in case of a child, it is only their parents and the lawful guardian of such child, they are included as a data principal. So basically the data is related to child, but on behalf of child, that their parents and the guardians will act as a data principal, right? So whatever be the responsibilities, whatever be the actions to be taken on behalf of the child, that will be taken by the parents or by the lawful guardian. Then a person with a disability, they are also the data principal. But again, their lawful guardian will take action on behalf of them, and those lawful guardian will be treated as a data principal, right? So in this context, everybody is covered to whom this data, personal data is related. They are covered as a data principal, right? So you and me, client, customer, patients, all those are now the data principal. So in a short way, all the Indian citizens are now the data principals, right? Then the next concept which is there in this act, that is data fiduciary, right? So who are the data fiduciary? So without going into the complexity, we can understand that all those persons, it includes individuals plus the legal entities, right? So all those persons, proprietors, partnership firms, LLPs, companies, the trust, NGOs, the cooperative societies, etc., etc. So all those persons who are collecting the data, right, collecting the personal data for certain processes, okay, and of course they are going to use that in a digital mode. So all of them are treated as a data fiduciary. So of course the banks are the data fiduciary, insurance companies are the data fiduciaries, stock brokers are the data fiduciaries, shopkeepers are the data fiduciaries, and the chartered accountants in practice, they are also the data fiduciary. because chartered accountants are collecting the data from their client, right? So chartered accountants are collecting the name, date of birth, even the account statement, right? So many things the chartered accountants are collecting from the clients. So the chartered accountants here become the data fiduciary. So here, with the impact, the hospital where we are sharing our data as a patient, so that hospital become the data fiduciary, right? So we under these acts now be called as a data fiduciary. It doesn't matter whether we are small or big, but all the chartered accountants in practice who are collecting an individual personal data, they will become a data fiduciary. And there are certain obligations, certain responsibilities casted on every data fiduciary to make the compliances of certain provisions. Which are those provisions? We'll discuss. Uh, that's what I was talking about, because we are, as a chartered accountant, we are collecting so much of the data. Of course, these are the basic data. We think that this is a basic data as a name, address, PAN, Aadhaar number, mobile number, and other financial data. We think that this is a normal data, but this normal data is now becoming the digital personal data, right? And of course, we require this for the accounting services, taxation services, advisory services, and there. That's what I said, that chartered accountants are also going to be now called as a data fiduciary under the provisions of this act. And there are certain responsibilities that will be coming up on the chartered accountants who are under the practice, right? Now, there is one more stakeholder, that is the data processor. See, I will collect the data from my client or from my customer, etc. But all the data I may not collect in my digital environment. So here, understanding of digital environment is also become essential. So if whether I'm storing the data, I'm using that data on only my digital environment, I will give you a simple example. Let us say you have collected all your clients' data as a chartered accountant, let's say for the taxation purposes. So you have collected name, PAN number, mobile number, addresses, etc., etc. Now, where you are storing that in your digital environment, whether you are storing that in a particular laptop, computer, server, but that is within your control, or whether you have a facility to store that data outside your digital environment. So some of you might have been accessing, storing that data in the cloud-based servers. It's possible that your taxation-related software, right now you are using the taxation-related software, but the taxation-related software is available to you through the cloud environment, right? So that software is not installed in your digital environment, but you are accessing that software, tax-related software, from the cloud-based environment. So here what is happening, you are sharing that data with that cloud-based service provider in a way, right? You are processing it, but the data is going to be stored in their environment, in the cloud-based environment. So whether you are providing the accounting services, accounting software where if the accounting software is installed in your digital environment, then there will not be the question of sharing of the data. But the moment you opt for the cloud environment software, that will amount to the sharing of data to the cloud-based service provider. Right. So certain things which is required to be shared with certain data processor. And in banking sector or in insurance sector or even in some hospital related sectors, medical related sectors, it's quite possible that all the services may not be possibly be given by a single person to with whom a data fiduciary, I may say, by a single data fiduciary. And for the various business activities purposes, they may require to share that data with the third party. So all those third parties with whom the data fiduciary is sharing that data, they are considered as a data processor, right? So in case of a bank, we can give the example as I have given for the chartered accountants who are using the cloud-based accounting software, cloud-based taxation software. So where the sharing of the data is quite likely possible. And one thing I would like to give cautious about that we are attending the batches of artificial intelligence. Yes, we must, but at the same time, sharing of any client's personal data on that particular platform, on the AI platform. So they will become the data processor. But for that, we need to obtain the consent. That is the obligation on us. And that's what we are going to discuss in the further slides also. Right. So in the bank, let's say that when the bank gives us this card, the credit card or the personal ATM card. So how they do that? So for that purpose, the bank is not printing all those cards. The bank is not embossing all those cards. So there are third party management services, right? Which as a supplier, they provide these services to the bank. So for that purposes, bank shares the data of us to such vendors, right? So those vendors will become the data processor. Again, when we do the transaction on the UPI or when we do the transaction through the mobile app, there is one processor we call in the banking terminology as a switch vendor, which also possesses a lot of data of our ATM cards, our PIN numbers, our UPI details, etc. So those vendors will now become the data processor. So these are the three important stakeholder I can say: data principal, data fiduciary, and the data processor. So all these are very, very important. You can say the links or the stakeholders under this act, and we have to play certain roles into that. Okay. And when we are talking about the data processing on the digital platforms, see how many activities they have largely covered, right? So they are talking about what is processing. So wholly or partly automation of the operations or the set of operations that is performed on the digital personal data, right? And they have included operations like collection. So let us say one company has been appointed to do a survey kind of and things for certain product, and they are visiting door to door for collection of the data for that survey. So even that collection, because what will happen after collection of that survey, a particular data, so obviously they are going to ask your personal data and they are going to process that through some system, digital system, to analyze the things. So even that collection activity is treated as a data process, right? So collection of that any data, of course, recording on the digital, because once you collect the data, of course, in our office also what we do, we collect the PAN number, we collect the mobile number, we collect the Aadhaar and etc. So we collect that either in a photo snaps or through a physical paper base, and then we enter those details in the tax software or in the accounting software, isn't it? So that is a collection, and then it is a recording, right? And then of course we are processing it for the desired results, what we wanted to do out of that. So all these activities like collection, recording, structuring, even the storage, that's what I said. When sometimes we feel that, okay, why the cloud-based services we are seeing that it is a data where the data is getting shared, because even the storage is independently treated as an operation. So when we are using the facilities of the cloud-based application, cloud-based softwares, and the database is residing into the cloud-based environment. So the storage of the personal data is there only, and that's why the storage understanding of the concept of the storage is also important, right? And one more important fact which is mentioned here in the as a part of the data processing is the sharing of the data, right? So if I'm sharing the data for any purposes, but without the consent, that is again a part, but even the sharing of the data to other person, uh, that also covers as a part of the data process, right? So a lot of things have been covered and minutely they are covered in this, and all these will have a lot of impact on the processing of the digital personal data. So every stage, what we are doing when we are gathering the data from our client, when any entity which is collecting the data from any of the client, so there may be possibility that they may involve two or three different kind of legal entities, and they are doing many of the separate. One will collect the data, one will record the data, one will store the data, one will use the data, right? So it may be possible that the personal data will be operated by so many legal entities, right? And for every of them, one could be the data fiduciary, others could be the data processor. So that relation needs to be confirm and ensure, and accordingly, the compliances needs to be understood, right? Going further, Avid, what is the crime in this? Why this act is important, right? What has made this act of so much of the talk about this act? And as I said, even before having full-fledged implemented that, why I'm saying that? Because iske abhi rules आना बाकी hai, right? So the draft rules were already published for the comment from the public at a large. But the final rules for the compliances of the various provisions is not yet declared. And recently, the ministers had quoted that we will come out with this kind of an final rule and regulations for this DPDP Act. So we have to wait for that finalization of that draft rules, right? But till that time, even before those rules are not yet implemented, the a lot of entities, banks, insurance companies, and other entities, they have taken the cognizance about this personal data protection of the Personal Data Act, and they have started working on that, right? Why this is so? Because a personal data breach that has been declared as a crime and an offense under this act. So what is that personal data breach? Look at what again they have covered in detail as a personal data breach. So any unauthorized processing of a personal data. What is unauthorized processing? If I have not given the notice to my client, if I have not obtained the consent from the client, that will be, and let us say that particular data is obtained, let's say only for the taxation purposes. And then I started utilizing for any other purposes. So what is the consent is given for? The consent is given only for the use of my data. The client has given you the consent for use of his or her data only for the taxation purposes. So you have to limit that. Okay. You cannot use that for any other purposes other than the taxation purposes. Right. So that otherwise that will be classified as an unauthorized processing of the personal data. So when we are looking for the compliances part of that, we should be very clear about what data we are obtaining. I call it as a data inventory, minimize that inventory, and we should have a clear-cut understanding for what purposes, for what cause. And of course, that cause needs to be legal one. Only for that 3, 4 purposes, I'm going to use that data. I will not cross that limit. Let us say that I'm going to use the name only for the accounting purposes. So limit the use of that particular name only for the accounting purposes. You cannot cross the boundary of that limit. Once you cross the boundary of that limit, then it becomes the unauthorized processing of the personal data. And importantly, look at the red font, accidental disclosure. That is also treated as a personal data breach. Why this accidental disclosure is important to be understood from the chartered accountant points of view? Because many of the chartered accountants, they are taking the help of the articles or the assistants in their work. And many times they share the data of their client through email, to a personal email to these articles or to their assistant's personal email. They share this data with the pen drive or the USB to these assistants, and then they start working on that. That's fine. They are working and they are supporting you, they are helping you. That's fine. But let us assume that unfortunately the articles or assistants USB or the pen drive or email is hacked, and thereby the personal data of our client is getting breached. So that there was no intention of ours to breach the data, but that has happened accidentally, right? Because somebody has stolen the articles pen drive, somebody has got access to that pen drive of the articles or assistants, and thereby he has stolen the list of our clients, the contact numbers, and other data. So there was no intention, but that happened accidentally. So that accidental disclosure is also included as a part of the personal data breach, right? And that is the serious thing which we have to consider. And that's how we need to understand our practices, to whom we are sharing the data, how we are sharing the data. All these things in a practice, we have to redefine it and relook at it. Accidental disclosure, acquisition or sharing of the data, as I said, sharing is not allowed. So hopefully now all those advertisement, all those unnecessary SMSs, all those unnecessary WhatsApp messages, that will get stopped, because without our consent, without giving notice to us, nobody can share the data with any third party. And if you will witness that you are getting such messages, and if you think that it is that is getting shared by one particular entity, so you can lodge a complaint with the data protection board, which is established under that. It is yet to be finalized, as I said, because rules are not yet finalized. And once the rules will be finalized, then there could be possibility that they will form this data protection board and they will start functioning for taking the cognizance of our complaints. So all these activities, basically from my point of view, unauthorized processing, this concept needs to be understood very clearly. Accidental disclosure, this is also an important concept under this personal data breach. Sharing or use, alteration or destruction, and loss of access to the personal data. So if your client is unable to get access to his or her data which is shared with you, right? So that also will cause an action under the personal data breach kind of an offenses, right? So basically they are covering these three basic security principles, which you might have heard in the DISA qualification course, that is confidentiality, integrity, and availability of the personal data. So it's all related to the security of the personal data. And if that has been not addressed to, and because of the negligence, because of not taking appropriate care, that is the data is not properly protected, then it would tend to offense as a personal data breach offense. And the penalties are very huge. Penalties are very huge. It starts from 250 crores. You can imagine it starts from 250 crores, which is not at all affordable to anyone. Even forget about the chartered accountants, to any other big corporates or big entities, they are also not going to afford this kind of an huge amount of entities, right? So this is not an affordable, of course, we can say by any calculation. So to whom this act is applicable? As I said, to every citizen of India, right? So it is applicable to every entity which is working within the territory of India. It is applicable to the digital personal data of every Indian citizen, right? And as I said, it is crossing the territory border of the India also. So if even the data of Indian citizen, which is getting shared out of the country, out of the territory of India, in that case also the provisions of this act is applicable. So let us say you have shared the data with some of the foreign entities, some of the foreign company. So for that company, they have to ensure the compliances of this areas. This is a reciprocal kind of an provision, you can say. So like in the GDPR, if any Indian company which is located in India and they are working upon the data of any European Union citizen. So as per the GDPR provisions, this Indian company, which is localized company, local company in India, they have to make a compliance of that GDPR, right? So this is a foreign law. GDPR for the Indian company is a foreign law, but still, if they are processing the data of European Union citizen, they have to make the compliances of that. Similarly, if the European-based company is processing the data of the Indian citizen, they have to ensure the compliances of this particular act, right? So all the social media companies, all the internet browsing companies, all the digital platforms, wherever you are getting connected with for whatever be the purposes, the provisions of this act about the protection of the personal data is now applicable, right? Act is already enacted. So provisions are applicable. Only the thing is that how, this is the question, and that will be answered. So this the finalization of the rules, right? Uh, okay, so the applicability is there, but where the provisions of this act is not applicable. Right. So of course, when we are going to share the data on person to personal basis with our family members, to our friends, to our relatives, right? That is with the domestic purposes. So I'm sharing my name, I'm sharing my details to my relatives, to my family friends, or even to my friends on a personal basis. So there, the provisions of this act is not applicable. Otherwise, that will be too much difficult situation. You can imagine, it cannot be imagined that. Right. So that is an exemption. So there the provisions of this act is not applicable. And second, the personal data that is made or caused to be made by publicly available. So when you are declaring yourselves with all the details on any of the public platforms, let us say on any of the social medias, you are writing the blog on any of the social platforms, digital media platforms, and there you are declaring your mobile number, your contact details, and whatever that stuff along with your name. So you personally are taking those actions, right? And that's why that is the action which is initiated by you on your personal wish, and that is publicly available. So those kind of and stuff will not be get covered under the provisions of this act. So there also we have to understand, and we have to make certain decision, because certain times you will wonder that SMSs are receiving, WhatsApp messages are receiving. Possibly now they may say that they have searched on the publicly available data that is available in the public domain through the internet browsing and so on and so forth. Again, many of the times when I took this forensic session, I actually request all the participants just to trace your own name on the internet browser and see what you found, right? So perhaps it will be you will be get surprised that somebody might have been opened the account, social media account in your name, because they have the catch to your publicly available all the personal data. So it's possible. So there is a possibility that next time when you will get the SMS after implementation of the act, or when you get the messages through the WhatsApp, so they may give you the reason that all this data is available publicly, and we get a catch of that, and then we started sharing out that. So now that becomes the personal behavior and the discipline in the personal behavior, which one has to look into, and they have to follow the discipline while making this data publicly available. Okay, so we are very clear about that. What is the provisions, core provisions? So we discussed about the three important stakeholders: data principal, data fiduciary, and the data processing. We have also now understood what is the offense under this, that is a breach of the digital personal data. And to avoid that, now there are certain obligations. Those are casted upon this data fiduciary. Again, who is the data fiduciary? The person who is collecting the data for the processing. And example, पेशेंट के लिए हॉस्पिटल फिड्यूशियरी है, क्लाइंट के लिए चार्टर्ड अकाउंटेंट फिड्यूशियरी है, कस्टमर के लिए बैंक डेटा फिड्यूशियरी है. Right. So you can understand the relationship. Now, one is data principal. So here, customer, client, patient, data principal, bank, chartered accountants, right, or hospital, they are the data fiduciary. Now, what are the obligation? As I said, the purpose of this act that the to protect, as I said, and the second objective is that if I'm sharing the data with any of these with the data fiduciary, that needs to be used only for the lawful purposes. Okay. So, okay, if I will visit the medical shopkeeper and he is asking the patient name, the details, etc., etc. Of course, I now have a right to ask why you are collecting that. So give me the reason how you are going to use that. So if he tells that, okay, I'm going to use it for generation of your acknowledgement of a receipt of a money, right? That is fine. That is lawful purposes. Right. And for that only I can give the consent. So bank, why the bank is collecting the data? Of course, there are multiple purposes for which the bank is collecting the data. And of course, those are lawful. I'm not going to share that. Even the bank is not going to share that data with any fraudsters, any scamsters and all that. Okay. Why the chartered accountants are collecting the data? Of course, they are collecting the data for the taxation purpose, for the accounting purpose, or for the auditing purposes. Those are the lawful purposes, right? But we cannot collect the data, as I can say, for, let us say, for giving tips for the money laundering purposes. So that is not possible. That is not allowable things, right? So nobody can have that kind of an actions, and they cannot claim that I am accepting this data and I'm collecting this data for the lawful purposes, right? So any illegal purposes, any kind of an offense related things, we cannot do with the data which we have collected, right? So there is an obligation of every data fiduciary to inform to the data principal what is the purpose behind collecting the name, date of birth, your mobile number, your email addresses, and so and so. Right. And that inventory should be minimum. It should not be maximum, because many of the times unnecessarily they are asking how many cars you are having, what is the color of the car, what is that data is required. Is that data is really required for the banking operation? It's not required. Right. So there could be a minimization role while collecting that kind of data. As a chartered accountant, we cannot ask how many cars you are having. Okay, if the declaration is required of some sort of wealth in any of the taxation purpose, that is fine. But otherwise, this general information may not be of a use, and we need to avoid a collection of an excessive data. आप जितना ज्यादा डेटा कलेक्ट करोगे उतना आपको उसका प्रोटेक्शन का बर्डन बढ़ जाएगा. सो द रूल हियर इज टू कलेक्ट ओनली द मिनिमम रिक्वायर्ड डेटा. दैट्स ऑल. राइट. विद द कंसेंट. सो एज आई सेड, कोई भी डेटा, व्हेन यू आर गोइंग टू कलेक्ट एनी single data of any pointer, there must be a clear cut consent that needs to be obtained from the client or the customer. And a notice needs to be given to the data principal. Right. What that notice or consent should be, what is the personal data they are obtaining, what is the purpose of that, and there you have to declare that as a data fiduciary that the same is processed or used only for that limited purposes. So let's say one client is visiting you, and that client requires your help in the GST return filing. Is not taking your help or support for the accounting purposes or for the income tax purposes. So what is your purpose limited to? Use that personal data only for the GST purpose. With that, you cannot cross the limit, and you cannot use that data for any other purposes. And in the notice to that client, you will have to mention that we are collecting the data, right? And that data will be processed only for the GST purposes, right? So that needs to be given in the notice, and the client needs to give you the consent. Okay, this is the data I'm sharing with you. This is the purpose. I'm giving the consent. Next time, suppose that client requires an additional services of income tax returns. So again, you will have to now, because first you have obtained the data only for the GST purposes. Now what you are suggesting, now the client is requesting you, okay, I have already given you the data for the GST, now process with my income tax return. So again, you will have to give the notice to the particular client, and you have to obtain the consent. Okay, now he is ready to give the consent to processing that data for the income tax purposes. Are you understanding that? So if your services are increasing step by step to a particular client, and you have obtained one notice, you are given one notice and obtained the consent only for the one purposes, that does not mean that he has given you the blanket consent. No way there is a blanket consent given for any of the purposes. So every step wise you may require to give the notice and get the consent from the client. That is must, right? How to give the consent and all these things are in detail described in that manner. Also, in the notice, the important thing which you'll have to mention, every data fiduciary has to mention, that in case the data principal observes that the data is not used as per the purposes, then in the notice, the data fiduciary has to mention to whom they can make the complaint. Of course, it is the Data Protection Board, which is yet to be established. But we need to give a link, number, etc., that in case of a breach of this kind of an purposes, the data principal can make a complaint, lodge a complaint to the board. So that also be the part of the notice. And notice management and consent management is coming up a very large scale business opportunities. as I said, we chartered accountant, we look at this data as burden, additional burden. But my dear friend, it's not like that. Already the tech persons, the software companies, the legal advisors, they are looking at it as an opportunity. Right? I'm looking at it as an opportunity because there is a lot of compliances which cannot be done on a physical paper. So this consent management, this data management, all this we cannot do every time on the paper-based manner. So there needs to be some software, there needs to be some tool, right? And those kind of softwares for the consent management, for the notice management is already in the market. Right. So you can understand how fast other entities are reacting with these provisions. And chartered accountant should be proactive to identify the areas where we can have the opportunities under this act. So I can clearly see if some of the chartered accountants are thinking about to start up a new kind of an entity, so they can enter into this consent management kind of a business, or they can enter into the notice management. Of course, nobody can just become the consent manager, because all those consent manager or the consent management company, those are required an approval from the data protection board. So it's not an easy thing, but of course the opportunities are there, and there could be strict conditions. There could be a requirement of certain amount of capital to become a consent manager, and all this thing that would be there. But again, auditing of that consent, technical audit, I'm talking about technical audit of that consent management companies, technical audit about that notice management companies, all that is coming up as an opportunity under this act for the chartered accountants, right? So consent management, so consent should be pre-specific, very specific, informed, and it is unconditional. So you cannot accept the client's consent with certain conditions. So it's not likely that. So if you want a consent for the GST purposes, that needs to be unconditionally mentioned. Yes, it is for the GST, and up to that, up to what level for the GST purposes, right? And shall signify an agreement to the processing of a personal data for the specific purpose. Again, I'm saying that you cannot, or any data fiduciary cannot cross the border of the purposes. So purposes should be very clear. So two things are very important: inventory of the data and purposes related to that data. That mapping document is very essentially be maintained by each and every data fiduciary, right? So as already I have told you that consent manager, that is upcoming as an opportunity. Already the companies have started gearing up all that, but it requires a registration with their data protection board, and it requires certain specifications, which of course the data protection board will come up with certain terms and conditions with which these consent managers can work upon, right? But the services of this consent manager is required in future for chartered accountants also. So we cannot escape from those services. If you are having a very limited number of clients, then it is possible to manage this consent and notices on your own. But if somebody is having even the 1,000 number of clients, 500 number of clients, then because consent management itself is a life cycle. Because what will happen? Uh, See, there could be life cycle to these consent managers. So today the data principal will give the consent. Tomorrow that data principal can withdraw the consent, modify the consent, and every data fiduciary has to keep all the records, all the track of whatever happening to the consent manager, consent management, right? So the life cycle starts from issuing of the notice. Any changes in the usage of the data, again, you will have to send the fresh notice. Then it may be possible that today the data principal has given you the consent for X purposes. Tomorrow they will give it for the Y purposes. Next time it will give for the Z purposes. Next time they can withdraw the consent for the X purposes. They can modify the clauses for the Y purposes. So all these things, and they may at any point of time, they may withdraw the consent also for one of the purposes. So you can't have control on what the data principal is going to do with that. Right? Nobody is having any data fiduciary. They will not have any control on the actions of the data principal. Right. So Considering all this life cycle of the consent management, it is not possible because this act requires to maintain the record of all these activities related to the notice and the consent. So tomorrow there is an audit. There is a provision for the audit, data audit under this act. So for that data audit, of course, the data auditor has to verify whether the record related to the consent management, consent modification, consent withdrawal, and all this life cycle is maintained, and that can be easily traceable. So I don't think manually it is possible. So some sort of an help in the form of software tool is required for this consent management, and that's where there is an opportunity also. But of course, we have to spend some amount for that also. What are the additional uh, obligations on the data fiduciary? So, as I said, these are the basic things that there should be a consent. The data fiduciary should use this data only for the lawful purposes and all that. But there are uh, additional, you can say, additional responsibilities casted upon the data fiduciary. A data fiduciary may process the personal data for any of the following uses for the specified purposes for which data fiduciary has voluntarily provided. Now, what will happen in certain the data fiduciary? There is an interesting thing. Let us say you want to make a courier to me, right? So without disclosing my name and addresses, it cannot be happened. So there we have to voluntarily provide our all the details. I mean, you will provide all the details of me voluntarily. Otherwise, that courier will not get dispatched. So those are the things which those data fiduciary or the post office as a data fiduciary or the courier wala as a data fiduciary, they have to keep that in mind. So some cases will be there where the voluntary data disclosure is required. Again, additional things, protection of the digital personal data. And there, the security mechanism. And the security mechanism, you cannot say that, okay, on a part of a declaration, yes, we have protected the data. It's not a simple declaration. Technically, you should be, a data fiduciary should be able to prove that they have technically protected the data. So some kind of an masking, some kind of an the encryptions, some kind of an restrictions on its access by some technical things. All this needs to be demonstrated at the time of if the entities, if any of the data fiduciary is covering under the data audit. So technically, the data needs to be secured. So when we are talking about the security life cycle there, so how we are going to give the access to that particular data and how we are going to give the access to whom and how. So again, the example which I have given, we tend to have that habit of providing the data to our assistant in the pen drive or transferring the data on to the assistants or articles personal email. So that practices, we need to redefine it because first one, we are not obtained the consent from the client that we are going to share the data within our employee, which may be ours, which may be on the contract basis or whatever. And the second thing is that how they are handling the data in their possession. So that will cause a lot of risk to us and that will tend to the accidental disclosures. To top that, we need to define from the access level itself where we are storing the data, how we are storing the data. So mostly now the encryption is the one way by which the data is going to be stored. It's not only the data as it is going to be stored, but the encryption is must for storing the data. So even in case of an hacking, nobody can, even for the backup purposes, many of the times we listen that, okay, for any unfortunate event, if that will occur, so I will take up a backup of my data. Fine, you can take up the backup. You let us say that you have take up a backup on the external hard disk and you carry that external hard disk daily basis to your home. So, but that is a practice. But whether the data in the backup is encrypted or not, because unfortunately, again, that external hard disk is stolen, right? That is unfortunately dropped at any place, and somebody misused the data contents into that hard disk. So the responsibility again we casted upon the data fiduciary. So handling of that data, even in the backup with the encryption, would be a must thing. So this will require the additional technical measures to be adopted by every data fiduciary. Now you can think how much efforts every data fiduciary has to take out. Don't think only about the chartered accountants. So you can imagine about the bank, you can imagine about the insurance companies, you can imagine about the e-commerce online shopping companies, isn't it? You can imagine about what will happen to the data which we are going to share with the day-to-day purposes for the small vendors and suppliers and all that. So a lot of complexities would be there in the protection field, right? And again, I can say that as an advisor, if we are good enough in the technological side, if you are DISA qualified, CISA qualified, if you know a little bit about the technology, so there is a lot of opportunity because even the customer to the client to whom we are providing the services as a tax auditor, they are also coming under the obligation as a data fiduciary, isn't it? But they are not aware about the complexities, what to do to make the compliances of these provisions. So there again lies one more opportunity for us, for giving them a consultancy, advisory kind of things or training kind of things for that purposes, right? So protection is again a technical protection. It's not only the protection in the word or in the paper-based things, but protection because in case support because of negligence, because of accidental disclosure, let us say the client's data is breached and complaint is lodged before the data protection board. So there you will have to, I mean, every data fiduciary, they will have to prove that they have adopted the sufficient technological protection to protect the data. And they have following up secured practices so that data is handled only in a protective environment, right? So, on that basis, the penalty will be charged. So, if we are not able to, any data fiduciary, if they are not able to take enough precaution to handle the data technically in a sound manner, right from access to the storage, whole life cycle, then that will be the difficult situation. So, this is a very, very important and interesting. The next obligation on the data fiduciary is that in case, suppose accidentally, the data got breached. So immediately, the data fiduciary has to inform to the data protection board, not only to the data protection board, to all the affected data principal, right? It can be possible that because of some attacks, cyber threats, cyber attacks, the data may got, encrypted. Even the data fiduciary, they do not have access to that data, or the data is destroyed, or the data is hacked because of the cyber threat. So it's immediate thing which every data fiduciary has to do. They have to first give the notice to the data protection board. That is the first responsibility. And to every customers, clients, we are calling them as a data principal. Each of them will get the intimation about such data breach, right? How to give that, when to give that, all that is defined under the provisions, and that will be come up with the rules also. The next obligation on the part of the data fiduciary, the retention period, right? So for how much period a data will be resided, will be stored with the data fiduciary, right? So of course, when we are continuing with the services, I have to maintain that data, right? But let us say the client relationship is ended now, right? So in that case, for how many period we have to maintain that data? Because in India, there are a couple of laws which requires the retention of the client's data for a number of years. In case of an PML, it is 5 years. In case of an income tax, it could be 8 to 10 years, so and so and forth. So we, as a policy, as a data protection policy, we need to define what is that period up to which we will retain that data. Because under this act, there is a right given to a data principal by withdrawing the consent to erase the data. So data principal can ask you to erase the data. That is the right which is given under this act to the data principal. So if the request would be there on the data principal side to you that erase my personal data, can we do that? Yes, unless and until the provisions of other acts are not going to be impacted upon. Because in India, if we are providing services to our clients, of course, as I said, there are other acts which requires retention of the data. So we have to inform to that client, yes, we will erase the data subject to compliances of this law. But that data, once the consent has been withdrawn, once there is a request from the data principal to erase the data, we or any data fiduciary, they have to make ensure that that data is not at all accessible unless and until it is required for any legal purpose. Right. So again, one more technical steps which every data fiduciary has to take it. Right. It's not only the retention, how we are retaining that. So once the consent is withdrawn, once there is a request to erase the data, that data needs to be segregated from our day-to-day usable data. And again, one more layer of protection will be required for that purposes, right? For in case of an child or in case of an person with a disability, so as I said, there is an obligation on the data fiduciary to obtain the consent from their parents or from the lawful guardian, and accordingly they have to take the make the use of that personal data. In the data fiduciary, you can say there could be one more class that is created under the provisions of this act. So you can say there are two types of the data fiduciary. One is normal data fiduciary and second one is a significant data fiduciary. So there are some additional, you can say the responsibility is casted upon this significant data fiduciary, right? So to whom they are classifying as a significant data fiduciary. So the person, any legal entity which is handling voluminous and sensitive personal data. So you can imagine all the banks, all the NBFCs, all the hospitals, big size hospitals, right? All these major corporates where a large amount of personal data is all the e-commerce, online shopping companies, digital platforms, social media platforms, right? The malls, right? So all these, they are handling voluminous personal data of an individuals. So they may become a significant data fiduciary, right? The risk to the rights of the data principal, somewhere there is a sensitive data because financial data, my health related data, this could be treated as a very much sensitive data. So if there is a risk of disclosure of that kind of data, so that may become under the significant data fiduciary. Of course, if any entity which is collecting the data and because of the collection of the data, it is threatening the sovereignty or integrity of the India by any action, that could amount to the that entity will also be declared as a significant data. Risk to the electrical democracy. So all these are the criterias on the basis of which an entity can be declared as a significant data fiduciary. But apparently, what I can see, the banks, NBFCs, financial companies, your stock exchanges, or the brokers, or insurance companies, the e-commerce companies, most of them will covered as a significant hospitals. They will going to be covered as a significant data fiduciary. I don't know how they are going to decide about the volume and the sensitivity of the personal data processed, because as I said, the financial data, the health related data is a sensitive data. So I'm just hoping that the chartered accountants will not be declared or not be get covered as a significant data fiduciary. But let us, we have to wait either for a notification, either for the rules to discuss and to decide about how they are treating this volume and sensitivity, right? So that we have to just wait for. But of course, all these larger entities, they will be definitely declared as a significant data fiduciary. And there are certain additional obligations on this significant data provision. What are those additional obligations? So they have to appoint a data protection officer, right? One more, I mean, not only data protection officer, but they will have to create a separate department as such to consider, to take the cognizance about the things which is required to make the compliances of the provisions of this act. But to start with, they will have to appoint a data protection officer. And the chartered accountants can also have an opportunity to work either a virtual data protection officer or in the job as a data protection officer. That is a good opportunity, right? So the data protection officer, of course, is responsible for implementation of all the compliances related to the provisions of this act. So data protection officer is a responsible person. And of course, he is the contact person for that data principal. So most of the complaints of the data breach of any of the client that will be dealt with by this data protection officer. So there is a huge amount of demand that would be there for this data protection officer. And you can imagine if those are the significant data fiduciary like the banks and the insurance companies and all that, how much a separate department and the number of persons will be required there to work upon. So that also coming up as an huge opportunity. This next obligation on this significant data fiduciary is there that the significant data fiduciary, it is mandatory for them to conduct a annual data audit. And from my eyes, I'm looking at this as an opportunity for the chartered. Of course, some certification, some skill set, some improved skill set is of course required, and we'll have to demonstrate those skill sets by obtaining that certification, passing of the exam, etc., etc. And those things needs to be, allowed as an eligibility criteria again by the data protection board. So we have to just wait for that. But the significant data fiduciary, they will have to conduct one more audit that is called as a data audit. And in the data audit, of course, as I said, how they are taking the measures to ensure the compliances of all these provisions of this act. So you can say the life cycle of the consent, notice, data principals rights, and so on and so forth. And of course, one more essential thing, the technological protection of the individual data. So it's a complete, total different technical field. I mean, right from the access to the storage, I'm repeating it again and again. So all that technical things with the technical measures, with the technical tools, the data auditor has to evaluate. So that is an annual kind of an audit which is required. In case certain threats happen at any of the data fiduciary, then the data protection board may, or internally also the data fiduciary may inquire the causes of the data breach, the responsibilities, and etc. So that I can say as a kind of a forensic opportunity for the data breach, right? So that is also an upcoming field as an opportunity for the chartered accountants, right? So forensic. In earlier my webinars, I have discussed one new concept that will come up. That is, we all know as a funds diversion. What is funds diversion? When I'm taking a particular funds for the particular purposes, I'm not using for that purposes, then it amounts to the funds diversion. Similarly, there would be the cases of data diversion. What is data diversion? So in the data diversion, I have obtained the data for a particular purposes, but I'm not utilizing for that purposes. I'm utilizing for sharing of that data for the advertisement purposes. So that is a clear-cut case of the data diversion. So there must be inquiry, investigation. A forensic of that incident needs to be done. And that could be done by the chartered accountants. Of course, again, as I said, you may require certain additional skill set, but don't hesitate to take that certification courses or the skill set available for that particular purposes, right? Periodic data protection of the impact assessment. So, you must be aware about that cyber security, cyber incidents management. So, likewise, every data fiduciary they have to evaluate how they are prepared with these incidents of the data breach and what would be the impact of that, right? So, that analysis, that assessment is also an obligation on this data fiduciary. An important part of this act, and that is universal right now. In every of the countries act, they have given certain rights to the data principle. And in short, it is like an RTI, a right to ask for the certain information, right? So data principle can ask us to show that they have given the consent that the data is going to be used only for the GST purposes. So they ask us, show us that our data is only used for the GST purposes, right? So they now have got the right to ask the information. In addition to that, they have got the right, as I said, right to correct the data. Many of the times, this thing we have witnessed and experienced in our purposes for so many times. There is a spelling mistake in our name, right? There is a spelling mistake in our addresses. There is a mistake in our email addresses. But even after giving, the request letters, they don't get corrected. But now here under this act, there is a right given to the data principal that if any data principal finds any of the data which is getting processed is incorrect, then they have a right to get that corrected. So now nobody can neglect those request letters for correction of the name, mobile number, etc. Right. They have a right to erase the personal data. They have a right to update the personal data also. Of course, erase they can request, but subject to the data fiduciary can accept those requests subject to the provisions of the other act. But of course, the data principal has a right to erase the personal data. Right. Of course, the data principal has a right to make a complaints with the data protection board or to the data protection officer, as I said, for the significant data fiduciary. And all these contacts and connections, uh, details for the complaints and all these things needs to be mentioned where in the notices which we are going to send to the data principal. The one more question oftenly getting asked whether the act is applicable, let's say for the older customers or for the newer customers. Many times this question is raised. The answer is that even if your clients which are with you for last 20 years, last 25 years, for them also the provisions of this are applicable. So you will have to start to obtain the consent and notices from now onwards for your older customers also, for your old clients also. It's not like that it is going to be applicable only for those clients which are joining after the enactment of this act. It's not like that. It is applicable for all the clients which are with me right now, right? One more interesting right which is given under this act, we cannot think about that, but that right has come out with this act, that is right to nominate. So I hope you have heard about the nomination facility in the banking transactions. There we required to give a nominee, a person, an individual being for the handling of the banking transaction after the date of the data principal. But here, the nomination facility is there so that after the date of the data principal, who is going to take care about the data which is shared by the data principal across the various entity. So every data principal can appoint a nominee and that nominee will take care how to handle the data. So that nominee will have now rights to give the consent, withdraw the consent, to exercise that right to correct, complete, update, or erase the personal data. So when we are taking the consent, when we are sending the notices, perhaps we will also have to ask about that data principal to our client to mention the nominee. So that nominee will handle the all these things after the death of the data principal. So that is very interesting kind of an condition which is there under this act. Certain exemptions are there where the provisions of these acts are, of course, not applicable. So, in short, for all the legal provisions, for all the legal requirements, the provisions of these acts are not applicable. So, let's say for the investigations, for the detections, okay, legal enforcement. So, in these cases, or for the court proceedings, right? The provisions of these acts are not applicable, right? In case of an merger, amalgamations, restructuring of the company, reconstruction of the company, in that case also, the provisions of these acts are not compulsorily be applicable. One interesting provision is there if the borrower has not repaid his installment interest to the bank or to the NBFC, and thereby the borrower has defaulted in the payment for the loans and advances. Then the financial institutions or bank, if they will declare that in a public notice or so and so forth, but there if they are mentioning the name of that particular borrower, so in that case, the provisions of this act is not applicable. For the recovery purposes, for issuing the public notice purposes, nobody can challenge that you are violated because you are not mentioned the purposes that in case of a default you are going to make it public, right? Because the basic thing is that these kind of an actions are exempted, and without the consent, this can be handled, right? And as I said, these things are applicable not only within the Indian territory, but it is applicable to all the companies which are processing the data of Indian citizens outside that. There will be the data protection board. The provisions are there under the act to set up the data protection board. And as I said, once the rules will be finalized and that the final rules will be publicized, then you will see that they will set up, the central government may set up this data protection board. The basic things which is required to understand about the data protection board is that the data principal, the customers or client can lodge the complaints with this data protection board. So the legal proceedings will happen in front of them. Then the approval of the consent manager will be given by this data protection board. Auditor may be required to submit the report to the data protection board, and the authority has been given to the data protection board to charge or to levy the penalty in case of an personal data breach, right? So there are certain rules for that, penalties and adjudication, but those are available with this data protection board. Now, coming up to the impact of this on a chartered accountant, specifically the chartered accountants who are in practice. So we as a chartered accountant, we are providing a number of services to our clients. So it could be in the form of auditing services, right? So what will happen? Let's imagine that we are doing the audit of a company. And in that company's audit, we are getting references of the various individuals' digital personal data, right? So what is the relationship of ours as an auditor with that data? Actually, who has collected the data? Data is collected by the company as a data fiduciary. And we are using that collected data by the data fiduciary for the audit purposes, for the audit services, right? Of course, as per the our ethical standards, right? Our code of ethics, we are bound by the confidentiality. Always, I mean, whether there was an act or not earlier also, but we were bound by that confidentiality clause under the code of ethics. So we are not allowed to share any of the data which is in our access or possession for any other purposes other than the lawful purposes. So when and now there is a practice that many of these companies or the banks to whom we are providing the audit kind of services, they are requesting us to provide that NDA, non-disclosure agreement. So whatever the data which is coming in our possession, even for the evaluation, examination purposes, for the audit, we are there. I believe that we are going to act as a data processor for the evaluation purposes. So the provisions of this act is going to be impacted upon us as a data processor. And that's why, as I said, already the banks have started taking the precaution that they are not allowing to share the data on the auditor's digital system. Whatever they are saying, that whatever the examination evaluation you have to do, you do it in our system. Right. And thereby they are taking the precautions not to share the data, even for the audit purposes, to the auditors. Right. But in many other companies, and that could be valid one to some extent, but of course, in some cases, we may require certain data for our working papers. So there could be some challenges on the implementation of provisions. But as I said, because of the code of conducts, code of ethics, and because of the NDA which we are signing with all those customers, all these clients for the audit purposes, I don't see there should be any hesitations on those companies, on those banking companies of sharing of the data for the working paper purposes. But yes, once that is in our possession, again, we will have to take a precaution to protect it in a well manner, right? So even though we are taking it as a printout, we will suppose that this is not a digital data. So we don't have to make that kind of a confusion or mistake. The printing papers which we are obtained for any borrowers related things, any of the vendors or suppliers related things. So that becomes a digital personal data of that particular borrower, supplier, etc. So just putting that in a file and not adopting any of the security mechanism to protect that particular data in a particular manner, that, and because of that negligence, if the data is getting shared, accidentally disclosed, then there could be a possibility of the complaints. So as far as the auditing services are concerned, we have to see what data we are obtaining for the audit purposes and how we are protecting that, and how much we are able to process the data within the client's environment and within our environment. So that that boundary needs to be fixed, and we have to see that which is the essential data which we require for our working paper purposes. So that is one thing for the audit services. As far as the accounting services are concerned, again, there could be possibility that we are obtaining the data as a data fiduciary or the data processor. Right. So possibilities that we are handling the accounting services, and the as I said, the particular software is stored in our environment. The server is in our office, right? So there we are acting as a data fiduciary, but the data is not going to be shared with any other person. But the moment you are going to adopt a software which is cloud-based, right? So there you are acting as a data fiduciary, and that cloud-based service provider is going to be acted as a data processor. Then what precaution is required on the part of the chartered accountants? So there must be SLA, there must be a NDA, there must be uh, an inspection on the part of the chartered accountant sometimes, that those rules of course will come up in the due process of this act, because this act is newly enacted. So in the due course, all these provisions will be there. So we have to ensure that even in the cloud environment, whatever be the data which is shared for the accounting or taxation purposes, those data is securely stored, right? And it is not getting leaked, it is not getting breached. Because ultimately, even if the data processor is leaking that data and the data breach is happening on the front of the data processor, it is the data fiduciary which is going to be responsible for that, right? So how the data is handled at that cloud environment, and the safety and security, and not disclosure of that data without the consent of us. And of course, when we are going to adopt this cloud-based technology for taxation purposes, for the accounting purposes, uh, in uh, in the notice to the client, we do have to mention the name of that particular cloud-based service provider with whom we are going to share their data. So in the notice, the chartered accountants, they will have to clear-cut mention that the data is going to be shared for the accounting purposes to XYZ Company Limited, which is the cloud service provider, or the taxation-related purposes, XYZ Company Limited. And we need to obtain the consent for that also. Sometimes client may deny. In that case, you will not be able to provide the services. Right. Even, the IP addresses of ours, of anybody, that could be an identification feature. And that is also covered. So any of the digital footprint by which any of the person can be identified, individual can be identified, those are the things which are also covered as a digital personal data. So things are going to be impacted like that. But as I said, when we are talking about the impact, or when we are talking about the challenges like these, because of the provisions of this act, at the same time, there are a couple of opportunities which are coming up to. The first opportunity I can visibly see is to act as a data auditor. Right. So annually data audit is required for the significant data fiduciary. So that would be the huge number of cases will come up for the compliances purposes. Second opportunity I can easily look up into, that is working as a data protection officer. It could be virtual data protection officer, or it could be in a job as a data protection officer. And a full scale of department working for the data protection. So there will be the number of well-educated, well-skilled staff is required, to protect the data, to make the compliances of backup. Because why I'm saying so, because considering the huge amount of penalty, as I said, 250 crores. So instead of making the payment of that huge amount, it is better to have the protection mechanism right at the place. One more important thing I would like to share here, that to mitigate this risk of the personal data protection, every entity, data fiduciary, they will going to opt for the insurance, right, as an mitigation measures, right? So everyone, even we as a chartered accountant, we have to think about to take an insurance in case the data breaches happens. So if the client demands the compensation, we should be able to pay that from the insurance cover. But the key question is, what should be the insurance amount? Right now, think here again as a banker, because I practice more into the banking area. That's why most of the time you'll get the sectors named here in this webinar. Because now you can imagine there is a bank which is having 15,000 crores as a deposit, and let us say 12,000 crore as an loans and advances. So total around 27,000 crores mixed business, and total business could be around 30,000 crores. So what should be the insurance of that bank for protection of that data? Because in the bank, what is that business means? Business means that data of 30,000 crores, it is a data. It is a binary data. It is an electronic data which is stored in their servers, isn't it? And if now the bank is asking that they want to take the insurance cover for the protection as a risk mitigation strategy to protect themselves from this huge amount of penalty, or to make the payment of compensation to the client. So what should be that amount of insurance they will have to consider? And there we chartered accountant, we are having the skill set of valuations. Only thing is that now we have to additionally learn about certain things about this data protection, valuation of the data. That is an upcoming opportunity for us, right? So valuation of the data, valuation of the digital personal data. So I can see the three core opportunities right up to here. So one opportunity, as I said, data auditor. Second opportunity, data protection officer. Third opportunity, a data valuator. Because we know how to make the valuation, right? And this is, even though the valuation of the data, as I said, some technical skills may be required, but we are in a better positions to provide that kind of services. So rather than thinking about the challenges, I'm more likely thinking about the opportunities which is coming up under the provisions of this act. And we have to always think about that. So what are the steps which we have to take about as a practicing chartered accountant? So my first advice to all of our friends is that first decide the inventory of the data which we are collecting, what we are collecting from the client as a digital personal data, right? Limit those inventory. So do not collect any excessive information which we cannot protect and which is not required at all for our service purposes. So please prepare a list of uh, all those, I can say, the data sets which is you require for your providing the services. Number one. Number two, you should be ready to map the purposes of each of these collected information. So why we are collecting the name, why we are collecting the date of birth, why we are collecting the addresses. And it is very easy to map because we have to mention that date in the tax return. We have to mention that date of birth in the tax return, right? We have to mention the email addresses in that tax return. That is the purpose. So map it in one particular way so that it is very easy to you to communicate in the notices to the your client. Make a list of all your clients because all the individuals, I'm specifically talking about this act applicable to the individual person. So if you are handling the data of an individual persons, make a list of all those clients to whom this act is going to be applicable, whether it is older client or whether it is the newer client. It doesn't differ. So all those things you'll have to identify how many childs with whom you are dealing with. I mean, of course, you must be dealing them with their parents, but their consent from parent is essentially be required. Then the next step would be that you restrict access to that data in a particular fashion, right? Don't give the access in a very loose manner where there is a possibility of a risk of accidental disclosure or sharing of the data which is out of your control. And that may happen because of the loose access given to the digital personal data. So have a look at how you are providing access to your staff, how they are going to use that data, whether any of your staff is carrying any of the personal data outside your office environment. Have a close relook of all these activities, right? Then some technical measures you'll have to adopt, like for the encryption, decryption kind of and things whenever required, right? Then consent management, notice management, that is also an important task which we have to deal with. So all these things as a step to step we have to consider. And again, as a policy matter, you decide what should be the retention period for the data which you are going to be collected from the client. Yes, if you are practicing in the taxation area, you are very well known what is the periodicity, but in a policy, you should mention that this is the requirement. So even if there would be the request from the data principal to erase the data, you should be able to reply that response that because of the provisions of this act, you will have to retain that data. But as I said, when you are retaining that data should not be accessible with ease to any of your staff. So that data which is required to be erased, that needs to be, even for the retention purposes, that needs to be kept outside the access of the normal data, right? So these are the steps which as a chartered accountant, we have to take about. But before ending of these things, let me share one video with you so that
Hey everyone, welcome to my channel. Today
just a minute, I will share the video. Just a minute. Just a minute.
Hey everyone, welcome to my channel. Today we're going to talk about something super important, India's new Digital Personal Data Protection Act. Whether you love tech, own a business, or just want to know what's up, this video is for you. So, what's this act all about? It's like a superhero for your personal data. It makes sure your information is used fairly, openly, and safely. Let's break it down with some simple words. Data principle, that's you and me, the people whose data is being collected. Data fiduciary. Think of them as the companies or organizations collecting our data. And data processor. They're like helpers who handle your data for the data fiduciary. Now here's the exciting part. This act gives us, the data principles, some serious power. You can see your data, fix any mistakes, and even delete it if you want. Imagine being in charge of your own information. Pretty cool, huh? But just like Spider-Man, with great power comes great responsibility. Companies, the data fiduciaries, have to follow the rules too. They have to use your data legally and openly. They need to keep it safe from hackers. And most importantly, they have to be responsible for how they use your data. Now, there are a few exceptions. Like, this act doesn't apply to data that doesn't identify you personally, or data you use for personal stuff like a diary app. So, don't worry about your secret diary. To make sure everyone follows the rules, there's a special group called the Data Protection Board. They're like the police of data protection. They can check if companies are following the rules, investigate any problems, and even give out fines if someone breaks the rules. And trust me, these fines are not small. Companies will definitely think twice before messing with your data. So why is this so important? In today's world, our online information is super valuable. Protecting it means protecting our privacy, who we are, and even our money. This new act is a big step towards keeping us safe and in control. So next time you're online, remember, you have rights. And now, there's a law to protect them. Thanks for watching. Don't forget to like, subscribe, and hit that notification bell for more videos. Until next time, stay informed, stay safe, and stay awesome.
Yes, so that's all from my side as far as this opportunity, challenges, and the impact of this Data Protection Act on the chartered accountants. So, Mayank, if there are any questions, we have a time of 10 or plus minutes, so we can have the questions if there are.
Yes, sir. So we have.
Your voice is not clear, Mayank.
Hold on. Am I good now?
No, it's still not clear.
Is it still breaking, sir?
Can you put the question in the chat box if your voice is breaking?
Am I not audible, sir?
Yes. Now you're right.
Yes, sir. We have three questions.
Yes, please.
So the starting one is PAN of vendors companies apply for data protection?
Sorry, can you please repeat it again?
So the question is PAN of vendor companies apply for data protection?
No, I'm not getting clear question. I'm not getting it clearly.
Yes, actually, it's written like that. The other one is when shopkeeper asks for the phone number, and when I say I'm not willing to give, he is not accepting, and insisting if I want a product from the particular shop. What should be done?
Okay, so this question, and there could be a lot of disputes like that. So when a shopkeeper is asking for any mobile number, So, as I said, now they will have to go through this processes of the consent and the notices, all this. But how can they do that? So, if we can handpick and go to the medical shop or the grocery retail shop, is it possible for them to do that? But of course, as a data principal, we have a right to ask them a question why they are asking for the mobile number. So, if they want that, they are asking it for the any acknowledgement purposes or whatever be the purposes, and if those purposes are the valid one, you can give the consent. Number two, if they are telling you that they wanted your telephone numbers because to share their products or to make the advertisement about that, so you have the right to deny that. And after denying that, if they are not providing the services, you can definitely lodge the complaint with the data protection board. It is not like that if you are not providing the consent to one of their purposes, that does not mean they should stop providing you the services. In such a case, the data principal has a right to lodge a complaint against that particular vendor to the data protection board. But as I said, all these things are, I mean, setting up the data protection board and all these things are yet to be implemented. But yes, when all these will be set, the data principal will get the right to make a complaint against that.
All right, sir. The question was this PAN thing only, and I'm not able to properly read it even.
Okay.
It's written is getting PAN card of the vendor allowed or not? Is it relevant, sir?
PAN card for vendor, yeah. If it is an individual, so it is not a vendor in the form of legal entity. Because again, I'm saying that this act is applicable for the data of an individual. It is not applicable to the data of an entity. So if the PAN number is of a company, that will not cover up into the provisions of this act. If the PAN number is of a partnership firm, that is also not going to be covered under the provisions of this act. But if it is a vendor is a personal, individual person, and somebody is accessing to PAN number of that individual vendor, then the provisions of this acts will be applicable to that. And with that notice, consent, and protection, all these compliances is necessarily be required for that PAN number which is accessed from the vendor.
All right, sir. That's it from the Q&A session. And really, thank you, sir. Really,
Thank
thank you,
you very
sir,
much.
for
Thank you, tech support. Thank you,
really
my, and
insightful.
thank you all the participants.
Thank you so much, sir.
Thank you.
Take care. Tech support, please shut down. Yes, sir. Yes, yes.